In healthcare, adult patients have the authority and thus are allowed to make their own medical decisions. This principle, respect for autonomy, is central to modern medicine. But what happens when a once capable adult loses the ability to make reasoned decisions? Who decides then? When a patient can no longer exercise decisional authority, difficult questions arise. Should clinicians, with their medical expertise, make decisions? Should family and friends who know the patient's life and values take the lead? Or should some neutral third party, free from emotional ties, step in to decide? It turns out patients themselves can still guide their own care, even when they cannot speak for themselves. This is possible through what are called advance directives. An advance directive is a determination made in advance, before illness or injury prevents them from being able to communicate their wishes. It states what the person would or would not want done, or at the very least, who should make the decisions on their behalf. Advance directives do not answer all concerning questions, but still, they can protect the patient's autonomy, reduce uncertainty, and help families and providers honor the patient's values. Yet research shows that fewer than 1 in 4 people have completed an advanced care planning process that results in formal paperwork. This video explores the process and the products of advanced care planning. By discussing and developing advanced directives, patients can ensure their voices are heard even when they cannot speak for themselves. While we often hear about advanced directives in healthcare, the broader process is called advanced care planning, which is a structured method for thinking through medical decisions before illness or injury makes it difficult to decide. It allows people to prepare for the unexpected, ensuring their values and wishes guide their own care. For example, a primary care patient may want to choose who will make decisions if they cannot. A dialysis patient may want to decide in advance to continue treatment if they lose the ability to consent. Or an oncology patient may want to plan treatment options, code status, and identify a decision maker before surgery. Planning can be done at any time while a person has decisional capacity. Best practice is to start early and revisit regularly. There are many approaches to advanced care planning. In this video, we will use the ICEP method: identification, conversations, education, and paperwork. Step 1 is identification, beginning by identifying 3 things. First, the values and interests that matter most, such as personal, cultural, or religious beliefs that guide medical decisions. Second, the people who could support or act as decision makers. They are often called agents or proxies. Importantly, an agent should focus on what the patient wants, not on their own preferences. Third, broader support systems, community, religious, or work groups. These support systems that the patient would want involved during difficult times. Step 2 is conversations, talking with loved ones about healthcare challenges, potential illness and injury, even death, can be very difficult, and so we often avoid talking about such serious medical matters. But silence leads to confusion when challenges arise. Talking openly with family, friends, and healthcare providers helps everyone better understand the patient's wishes. Step 3 is education. Patients themselves need to understand 3 things. 1. Their current health status and treatments. 2. Possible future conditions they may face. And 3. The medical options available. What is possible, what is not, and how treatments like ventilators or CPR or dialysis actually work, and when they may not work. Finally, step 4 is paperwork. Again, it is common to hear about advance directives. Advance directives are the legal documents that record healthcare decisions for the future. But this paperwork should come last in the process of planning. After values are identified, conversations are had, and education is provided. And the documents should reflect the thoughtful processes and insights that came before it. Once complete, all parties should be made aware of the decisions that have been made, and the paperwork should be given to providers, family members, and any others who may be impacted by the decisions. But it doesn't end there. Advanced care planning is not a one-time event. It should be revisited every few years or when health or life circumstances change. People are allowed to change their minds, and new medical therapies may create new options. Documents have legal limits, but the process and reflection and conversations should continue. Advanced directives come in many forms and meet various purposes. They are legal tools that help ensure a patient's wishes are respected when they can no longer make decisions for themselves. Broadly speaking, advanced directives serve two functions: treatment directives and proxy directives. And sometimes both functions are combined into one single document. Treatment directives allow a person to explain what kinds of medical treatments they do or do not want under certain conditions. For example, someone may want chest compressions if they have a heart attack, but may not want long-term dialysis if their kidneys fail. The most well-known treatment directive is the living will, sometimes called a treatment declaration. A living will outlines what medical treatments a person would or would not want and under what conditions. The clearer and more specific the language, the better. Phrases like "no heroic measures" can be difficult for clinicians to interpret. Instead, precise instructions help translate wishes into medical orders. Living wills extend a patient's autonomy, often overriding substitute decision makers. However, there are some limitations. For instance, clinicians are not required to provide treatments that they believe are medically inappropriate. In such cases, providers should help transfer the patient to another provider if one can be found and is willing to honor the request. Some treatment directives function as direct medical orders. One example is the Out-of-Hospital Do Not Resuscitate Order, or DNR. These legally binding documents tell emergency personnel not to attempt resuscitation, but it must be readily available at the time of the arrest, or the resuscitation will be presumed. Another order-based directive is the Physician Orders for Life-Sustaining Treatment, or a POLST. This document records patient decisions about end-of-life care and carries the force of medical orders across hospitals and emergency services within a state. Unlike living wills, POLST forms are legally standardized in each state, and while certain specifics will vary from state to state, each POLST must be signed by both the patient or their legally authorized representative and a physician or possibly another licensed medical professional. A less common treatment directive is known as a psychiatric advance directive. Recognized only in a few states, these documents allow individuals with mental health conditions to state their treatment preferences in advance. For example, someone with bipolar disorder may authorize medication during a manic episode, even if they later refuse that medication during the episode. Such agreements are sometimes called a Ulysses contract. The second function of an advance directive is the proxy directive. Instead of focusing on treatments, proxy directives identify a person or persons who should make medical decisions if the patient cannot. The most common proxy directive is the durable power of attorney for healthcare, sometimes also called a medical power of attorney. This document designates someone as a healthcare agent to make medical decisions on the patient's behalf. The agent has the same authority as the patient, though they typically cannot override instructions in a living will. One small note is that it is important to specify power of attorney for healthcare, since not all powers of attorney cover healthcare decisions. Some, in fact, may only cover finances or other limited matters. Now, some states use the term healthcare proxy instead of healthcare agent. Depending on the jurisdiction, this role may carry the same authority as an agent under the medical power of attorney document, or it may be more limited. For example, it may function whenever a patient loses decisional capacity, but it might also be limited to apply only when a patient is permanently unconscious or terminally ill. State laws determine when advance directives take effect. In most cases, if a patient has decisional capacity, their advance directive does not apply because the patient can speak for themselves. But when capacity is lost, the type of directive that exists and the particular state's laws dictate whether it becomes operative. Again, some directives apply whenever a patient lacks capacity, while others only apply under specific circumstances, such as permanent unconsciousness or terminal illness. Advance directives, whether treatment directives or proxy directives, are essential tools for honoring patients' values and guiding care. Understanding the type of directives, their limits, and the laws that govern them ensure that patients' voices are respected even when they cannot speak for themselves. But advance directives may prove less than adequate if not carefully planned through a process of identifying values, talking with loved ones and providers, and learning about health conditions and treatments before making and writing down decisions in advance of the need.